If you have a collections lawsuit, do not make these two mistakes. If you're going to go to trial and you're going to make an argument, do not make these two mistakes. Welcome back to Credit Nerdery, brought to you by Kyronic Financial, Kyronic Credit Products. Welcome back to Credit Nerdery. Alright, I want to just do a quick video here and tell you two things that I see become very prominent and is peddled in different areas when you're dealing with collections lawsuit. As you know, this channel, we specialize in credit repair and we specialize also in collections and collections defense. Welcome back. If you have a collections lawsuit and you're making an argument to go and make a defense in against whoever sue you, if they actually sue you, you need to understand this. There are three things you must not do if you want to have a chance in winning or have a chance in getting the case. Basically, the judge don't automatically rule against you. The first thing you need to do when you actually have a case, deny everything except if your address is correct. You acknowledge your address. Why you need to deny everything? You need to deny it in such a way where it doesn't look like you're outrightly lying. Because once you deny it, it will be the burden of proof will be on the other side to prove that the claim that they're bringing against you is valid and it is a matter of law. What does that mean? It is grounded in law and they have a case. They can prove the damages that they incur that causes them to sue you. Once you go to the case, I have studied case after case. I have studied collections case after case. And one of the themes, and I have seen it in different states and different parts of the country, one of the themes that automatically cause the defendant to lose is them not denying that the account is theirs. Once you don't deny that it's yours, and you can deny it in such a way, because I remember I saw a case where this young man lost the first episode, if you put it as that, the first episode, and he appealed the case. And even though he lost, when he appealed, he won. And you know what he won on? He won on the hearsay doctrine, which that's something that we will get into another time. And the rules of evidence, business rules of evidence and the hearsay doctrine. That's what he used to win on the appeal. But in his case, in the beginning, he denied it. And every case that I have seen, if you want to give yourself a shot, or give the judge something to work with as he makes his decision, you cannot own the case up front. Once you own it, you're gonna lose. You're gonna lose. You're gonna lose. So that's the first thing you make sure. And you don't deny it in a blatantly overt way where it becomes something that looks like you're lying. You say, I don't recall this account or something like that. So it's a memory issue. You're denying it, but it's a memory issue. And then let them prove their case and establish their case. And then you move from there. The next thing that you don't want to do, and this is more so the argument that you're making in defending yourself. There are two arguments that I see making cases, and you have books that are written on collections defense that have one of this argument in it. And there are actual cases with it. I remember this case with this, I don't remember the actual case name, but I will tell you, you can always look it up. Citibank versus a lady. And she lost that case for $94,000. And you know the argument that the judge made? That she did not deny the case. She did not deny that she made the charges on the credit card. What the argument that she tried to make is Citibank's standing. What is standing? Whether Citibank had a legitimate right to sue her on the account. So that is standing. What end up happens is that Citibank sued her and she did not deny that she made the charges. Now why did the charges came to $94,000? Because Citibank got the judge to actually get her to pay their attorney fees and all kind of other fee, and it came up to $94,000 when the card was not even $94,000. And the argument that the judge lay out is that she never denied the charges that she made them. I say I have another Citibank case in New York with another man, and he never denied them, and the judge said you never denied them, so therefore you are guilty and you need to pay the 2000 and change that they sue you for. So you don't want to go there and don't deny what is going on. You need to deny it and you need to take it from there. The next thing that the argument that you don't want to go there and make, as I said earlier, that relates to standing, is to say that the bank does not have the right to collect on the credit card because they sold it to their master trust. If you don't know this is common practice within the banking sector. When you open a credit card account, they sell the receivables to their master trust and then repackage that sale of your debt as actually investment that they pay investors on for a period of time. The banks do this. All the banks do this. So when you open a credit card account and you are paying the bank and paying interest, the bank is also making money off that card by selling the card into their master trust, and the master trust issues certificate against the receivers, which would be your credit card payment, and basically collect on it again. So because they do this, individuals use this argument to say that Chase or Citibank or Capital One or whoever it is does not have the right or the legal ownership of the account, so as a result they should not be suing on the account. And the courts have ruled no, they have the right, because the trust and all of those are not actual entities that basically have the ownership. It's just a pass-through entity that they use to create the contracts and to sell the investment, because they don't have employees, they don't have XYZ and so on and so on. Do not make that argument if you're going to defend yourself. You're not going to win with it, and the court is going to rule against you, and there are legal precedents in the system for cases like those where the court ruled and showed those arguments are as nonsensical. The third argument that you don't want to make: if the account is charged off, do not go there and make the argument that the charge off is income. So as a result, they can't collect on it. Once the account is charged off, the bank, once they own it and don't cancel the debt or forgive the debt outright, or the debt is discharged in bankruptcy, they have the legal right to still collect it, because to write it off as a charge off is actually a federal requirement for banks in order for accounting practices and the proper measurement of their asset class and the assets that they have. So therefore they write it off and then they go to IRS, and when they go to IRS give them credit under profit and loss. It does not mean that they don't have the right anymore to collect. So do not go there and make the argument. There are cases like this, and this is in my the quote from the quote from one of the most famous cases like this is in my charge-off removal packet, where when I'm laying out the nature of a charge-off, and in the FTC document, the evidence of indebtedness where charge-off is concerned. That document quote this case, and I also read the case myself, and I also quote it in my charge-off removal packet. That is in my Tyronic Credit Products website. Do not go there and make that argument that the charge-off is income, so therefore you don't have to pay it. Not going to work. Courts have seen this before. Courts have ruled on this before, and whoever make the argument never win. So please do not make these mistakes. Peace. Have a good day. When you go, make good argument, defend yourself. Start by denying. Do not make an argument that the charge-off is income, so the bank does have the right to collect on it, or the loan or whatever, because it's charged off, so they don't have the right. And 3, you don't want to also make the argument that because the account was sold as investment into receivables to a master trust, then it means that you cannot actually, they don't have right to collect from it. You're not going to win if you make those arguments, and the court is going to rule against you. Peace. I hope this is helpful.